After hearing the conflicting expert testimony detailed above, and viewing the varied exhibits offered by the parties, the court determined that the ECAD system was technologically feasible prior to Meininger's employment with Pentec. In so concluding, it is evident that the court, sitting as fact finder, chose to credit Amerman's testimony as the more credible. Moreover, Pentec's assertion that the trial court disregarded the opinions of both experts is belied by the record. Amerman unequivocally testified that, in his expert opinion, technological feasibility was achieved prior to Meininger's employment with Pentec. His determination that costs should have been capitalized as of November 1986 was based upon the fact that that is the month at which Pentec begins its new fiscal year. Amerman did not testify, as Pentec asserts, that technological feasibility actually occurred in November of 1986. Pentec's brief at 11, we therefore hold that the trial judge, sitting as fact finder, acted well within the bounds of permissible discretion in concluding that technological feasibility occurred prior to Meininger's employment with Pentec. Therefore, because this finding was supported by competent evidence, Pentec's initial issue must fail. Next, Pentec asserts that the trial court erred in admitting the testimony of Meininger's expert witness, Brian Amerman. More precisely, Pentec avers that Amerman's testimony should have been excluded as a discovery sanction for failing to comply with the Pennsylvania rules of civil procedure relating to disclosure of expert identity and testimony. Pentec presents several arguments in support of this assertion, as each argument alleges the failure to comply with some portion of Rule 4003.5 governing discovery of expert testimony and trial preparation material. We will reproduce the pertinent portions of the rule at the outset. Discovery of facts known and opinions held by an expert, otherwise discoverable under the provisions of Rule 4003.1, and acquired or developed in anticipation of litigation or for trial, may be obtained as follows. A party may, through interrogatories, require any other party to identify each person whom the other party expects to call as an expert witness at trial, and to state the subject matter on which the expert is expected to testify, and the other party to have each expert so identified by him state the substance of the facts and opinions to which the expert is expected to testify, and a summary of the grounds for each opinion. If the identity of an expert witness is not disclosed in compliance with subdivision of this rule, he shall not be permitted to testify on behalf of the defaulting party at trial of the action. However, if the failure to disclose the identity of the witness is the result of extenuating circumstances beyond the control of the defaulting party, the court may grant a continuance or other appropriate relief. First, Pentec claims that Meininger violated Section A(1)(a) of the rule relating to disclosure of an expert's identity. Specifically, Pentec claims that the disclosure of Amerman's identity 6 days prior to trial did not afford Pentec with sufficient notice and time to investigate the expert's credentials. In response to an interrogatory from Pentec, Meininger responded that he intended to call, as an expert, an accountant from the firm of Amerman and Company. Additionally, Meininger briefly outlined the proposed trial testimony of the as-yet unnamed expert, stating that the testimony would relate to whether Pentec's costs were properly expensed and capitalized. Thereafter, 6 days before trial, Meininger supplemented his response by identifying Amerman by name and further outlining his proposed trial testimony, as well as the facts supporting such testimony. Although Pentec objected to Amerman testifying at trial due to the alleged dilatory disclosure, the trial judge allowed Amerman to testify. Counsel for Pentec cross-examined Amerman regarding his credentials and then stated that he had no objection to Amerman being qualified as an expert. In light of this uncontroverted record evidence, we find Pentec's present challenge to be without merit. Indeed, Pentec's allegation that Meininger waited until the eve of trial to disclose his expert is without a factual basis. Pentec's brief at 17 The purpose of subsection A.1 is to prevent a party from gaining an unfair trial advantage by withholding the identity of expert witnesses for so long that the opposing party is without the time and resources to investigate the witness's background, credentials, and reputation. Instantly, Pentec was afforded 6 days to determine whether Amerman should properly be qualified as an expert and, at trial, stipulated to Amerman's credentials. We therefore hold that Pentec's present challenge is without merit, and that Meininger's disclosure was in compliance with Rule 4000 3.5a 1a. Pentec next claims that Meininger violated subsection A.1b of Rule 4000 3.5 because Amerman's report did not set forth with specificity the expert's opinions and grounds therefor. Instead, Pentec claims the report was merely conclusory and did not afford Pentec the opportunity to mount a meaningful and complete defense. Meininger initially responded to Pentec's interrogatory as follows. Answer, accountant from Amerman & Co. It is expected that testimony will be presented showing that the value of ECAD Services Inc. is understated on Pentec's books, that the value of agreements between Pentec and Mr. Meininger and or ECAD are not considered or stated. Also, that R&D was expensed and not capitalized. Also, that salaries, administrative costs, and leases with management-owned properties were and are excessive and unreasonable. As previously stated, this answer was supplemented pre-trial with a letter from Amerman to Pentec, in which Amerman stated that, in his opinion, Pentec's audit was not completed in accordance with generally accepted accounting principles because research and development costs were expensed rather than capitalized. This, in turn, caused the value of Meininger's stock in Pentec to be undervalued. After reviewing this discovery, we cannot agree with Pentec that Meininger's response was merely conclusory. In fact, Amerman's conclusion that the stock was undervalued was supported by the disclosure of his opinion that the cause for the undervaluation was the failure to correctly apply the relevant accounting principles. Moreover, Amerman specifically identified SFAS 86 as the significant accounting principle that he believed was wrongly applied in the initial in-house audit. We therefore hold that Meininger did not violate Rule 4000 3.5 A.1b. In compliance with the rule, Meininger's initial answer and the later supplementation served to fully notify Pentec of Amerman's proposed opinions, conclusions, and the grounds therefor. In light of the record evidence, Pentec cannot successfully claim pretrial ignorance or unfair trial surprise. Pentec's final assault on Meininger's compliance with the discovery rule concerns subsection C, which states that an expert's trial testimony may not be inconsistent with pretrial disclosures or go beyond the fair scope of discovery testimony. In support of this claim, Pentec alleges that Meininger's pretrial disclosures did not specifically reveal that Amerman would testify regarding the date at which the ECAD unit achieved technological feasibility. Again, our independent review leads us to conclude that this allegation is baseless. Although not using the exact words technological feasibility, Meininger's answer and Amerman's report unequivocally stated that Amerman believed that research and development costs were expensed when they should rightfully have been capitalized. It is an elementary accounting principle that R&D costs are only expensed until such time as technological feasibility is achieved. Costs incurred after this point are capitalized. We find it implicit in Meininger's and Amerman's answers that Amerman would give his opinion as to when the ECAD unit was technologically feasible. It would otherwise be impossible for him to conclude that costs should have been expensed and not capitalized. Pentec's claim of trial, surprise, and resulting prejudice is, therefore, without merit. Pentec's final claim on appeal is that the trial court erred in awarding attorney fees to Meininger. After reviewing the applicable statutory authorities and the trial court's stated justification for awarding the fees, we conclude that the trial court erred, and thus we reverse that portion of the order. Pursuant to 42 PYAC S.A. Section 2503, counsel fees may be assessed against a party to an action that has, inter alia, acted in a dilatory, obdurate, or vexatious manner, either during the pendency of litigation or in commencing litigation. Upon a finding of such behavior, an award of attorney fees lies within the sound discretion of the trial court. This court will not disturb such an award, absent a palpable abuse of that discretion. See, for example, Thunberg v. Strauss, 545, PA, 607, 615, 682, Etude, 295, 299, 1996. Instantly, although not specifying which subsection of Section 2503 that it was relying upon, the trial court imposed attorney fees against Pentec as a sanction for its perceived pre-litigation bad faith conduct. As the trial court held, the basis of our decision was that Pentec engaged in bad faith conduct when it valued Meininger's shares of Pentec stock. The progress of this case and the need for litigation at all was influenced by the lack of fair dealing on the part of Pentec. Perhaps if a fair calculation of the stock's value had been made, based upon the evidence in Pentec's own records, a resolution of this matter could have been reached without resort to the courts. Without commenting upon the accuracy or propriety of the trial court's underlying conclusions, we can readily state, as we have in the past, that Section 2503 does not apply to conduct that occurred prior to the commencement of this suit. Rumbaugh v. Beck, 411 PA. Super 220, 240, 601 A2D, 319, 329, 1991. We therefore hold that the trial court abused its discretion in awarding Meininger counsel fees based upon Pentec's pre-litigation actions. Accordingly, as there are no allegations or proof of bad faith conduct in the commencement of the suit or during the pendency of this litigation, the award is without statutory support and must be reversed. We now turn to Meininger's cross-appeal, in which he claims that the trial court erred in finding that the requisite $250,000 threshold of ECAD sales was not met prior to Meininger's termination of employment, and that, therefore, Pentec was not required to create a spin-off corporation in which Meininger would own 49% of the stock. As previously stated, the parties' employment contract included a business incentive, which contemplated the creation of a spin-off subsidiary corporation, provided that certain prerequisites were met. As a threshold, it was agreed that the ECAD business must reach $250,000 per year in gross revenue. At that point, the subsidiary corporation would be formed, with Pentec and Meininger holding 51 and 49% of the shares, respectively. Capitalization for the new company would be as follows. Pentec would make an initial investment of $51,000. Meininger's initial investment, valued at $49,000, would be evidenced by the intangible value of the technology Meininger brought to the corporation. Thereafter, any additional monies expended were required to be matched by the parties on a dollar-for-dollar basis in accord with their respective holdings. On appeal, Pentec strenuously asserts that the threshold trigger level mandating creation of the new company was to be measured in gross service revenue per year, rather than gross revenue per year. This is an important distinction, for a company's gross service revenue may represent only a fraction of its overall gross revenue. The confusion as to which revenue control stems from the fact that the parties' agreement was expressed in two writings, each of which contained language identifying a different trigger standard. Paragraph 8A of the employment agreement specifies employee will seek to develop a profitable ECAD services business, burdened engineering and technical labor exclusive of travel, equipment, and other costs, to a level of $250,000 per year gross revenues as determined by the cumulative revenues earned during each fiscal year. Thereafter, the agreement provides that, upon attainment of the goal in subparagraph 8A, Pentec would take the necessary legal steps to form a subsidiary to support the ECAD technology. Finally, subsection 8C states that the guidelines for the new company's operations, should it be formed, would be outlined in Exhibit B. Exhibit B, captioned Guidelines for Forming a Subsidiary Company, to supply ECAD equipment and services, provides that the spin-off corporation would be created at the threshold of $250,000 per year in gross service revenues. Pentec currently asserts that ECAD's gross service revenue was only a portion of ECAD's total gross revenue, and that it was the parties' intent that gross service revenue be the controlling trigger point. While the trial court agreed with this assertion, our careful review of the record leads us to conclude that the parties contemplated total gross revenue to be the proper calculation. Accordingly, we are constrained to reverse the trial court. At trial, Sheldon Lefkowitz, president of Pentec, testified as to his understanding of the terms of the spin-off incentive. As follows: Q, could you explain generally what the purpose of that provision was to your understanding? Oh, well, since we had a goal of creating a commercially viable business, from this idea that Meininger brought to us, we needed to establish, in very simple terms, the level of business that would allow us to feel comfortable that this business would be self-sufficient, that it could provide without subsidy. We naturally started with a very small company, 1, 2, eventually 3 people, and we picked a number of $250,000 of gross business a year as being a level that would establish itself as being able to pay the bills and show some kind of small profit, if you will. It was a kind of breaking point that we picked. As we reach the conclusion of this intricate legal story, the final decision in Meininger versus Pentec underscores the importance of precise language and mutual understanding in contractual obligations. The courts meticulously dissected every clause in testimony to arrive at a fair resolution, highlighting the necessity for both parties to uphold their end of the bargain. The conflicting interpretations of revenue thresholds and the specific terms of the spin-off agreement shed light on the potential pitfalls of dubious contract language. It's a cautionary tale for businesses and employees alike to ensure that every detail is clearly articulated and understood from the outset. In the end, the court's decision to reverse the trial court's findings on the revenue threshold reflects a commitment to fairness and the original intent of the agreement. Richard Meininger went on to found Care Services, Inc. For over 30 years, Care Services has provided cable testing and EMI/RFI troubleshooting services to maintain cable circuit health in nuclear facilities. Their advanced care, cable condition monitoring system, performs non-destructive electrical tests to assess cable integrity, identifying issues such as impedance problems, moisture intrusion, shorts, and open circuits, while minimizing personnel exposure to harsh environments. Integrated with user-friendly software, the system trends recent measurements with historical data, flagging anomalies for proactive maintenance. Care Services offers a nuclear instrumentation testing program to diagnose and resolve electrical noise issues in critical monitoring systems, SRMs, IRMs, and LPRMs, preventing operational disruptions like SCRAMs. Their comprehensive LPRM testing automates evaluations, detects signal integrity issues, and rejuvenates detectors with solutions like metal whisker burning, saving time and resources. Care Services also offers plant life extension testing to meet regulatory requirements, manage cable aging, and support long-term nuclear plant operations, and ensures compliance with NRC guidelines and addresses cable aging for plants seeking long-term operation licenses, establishing baseline data for future troubleshooting. Additionally, their cable aging and condition monitoring program evaluates conductor, connector, and insulation health, offering predictive insights and troubleshooting tools to resolve performance issues. These integrated services ensure the safety, reliability, and longevity of nuclear power plants and their cable systems. Richard is my grandfather and the most influential person in my childhood. He did a lot to inspire learning and curiosity. He taught me to think about solving problems, and he always helped me find solutions. He taught me about the scientific method, how to work with my hands, how to fix things, and how to use first principles thinking. And he shaped my way of thinking about the world. He would tell me that a person's mind is their most important tool. He challenged me to think differently than everyone else. Anyone who knew my grandfather would tell you that he was stubborn and particular and often pessimistic. His opinions were straight to the point and no sugarcoating on it. Ironically, I didn't shy away from reciprocating those values because they came naturally to me as well. No other debate I've encountered as an adult comes close to the ones we shared. I am extremely thankful for the times we shared. Through this video, I hope to honor and preserve his legacy and the profound impact he had on my life. He influenced how I think about businesses and analyze stocks and go about my life. His journey through this legal battle is just one facet of the interesting person he was. Thank you for joining me in this tribute. Until next time, remember to subscribe, hit the notification bell icon for more videos, and please smash the like button if you enjoyed this one.